and then maybe followed by your colleague.
Thank you, Mr. Chair, honourable speakers. I'm with the Canadian Criminal Justice Association. As noted, my name is Howard Bebbington. I am a board member and the chair of the Policy Review Committee. If you please, for purposes of brevity, rather than say Canadian Criminal Justice Association every time, I think I will simply say CCJA. With me today is my colleague, François Boillat-Madfouny, a member of the Policy Review Committee. And I would like to start by noting for the committee, and perhaps of interest, that the CCJA will be 100 years old next year in 2019. We are an independent, national, voluntary sector organization working for an approved criminal justice system. We have 700 members across the country representing various perspectives on the criminal justice system, including criminologists and other academics, lawyers, police, victim support workers, probation officers, parole officers, and other correctional workers, etc. We exist to promote rational, informed, and responsible debate in order to develop a more just, humane, and effective criminal justice system. We publish every year the Canadian Journal of Criminology and Criminal Justice, and every second year we host the Canadian Congress on Criminal Justice. Now, senators have our brief, so I don't propose to go through that in any detail, but I do want to start by applauding the federal government for its efforts to update and modernize what is a difficult area of law that has been highly litigated and has been conducive to a great deal of delay before the system. We think it particularly important with the advent of the legalization of marijuana. However, we do have several problems with the bill. Our major concern is with the evidentiary basis for the so-called per se offences, the blood drug concentration offences. We firmly believe that criminal justice policy must be evidence-based, but we have very significant concerns about the evidence-based for the per se offences. I think the committee need look no further than the evidence that has already been led before the committee, starting with the Minister of Justice, who in her testimony admitted quite candidly that the science around drug-impaired driving, and my apologies, this was in her appearance on January 31st, that the science around drug-impaired driving and recognition of levels of impairment with an individual is not as advanced or as exact as alcohol-impaired driving. Mm-hmm. She also referred to the need to continue to follow the science. She referred to blood drug concentrations, pardon me, it's a little bit tricky for my tongue instead of the BAC, of both 2 nanograms and 5 nanograms, both of which exist in different jurisdictions. Apparently Canada will adopt both for different purposes, but again, we question the science of choosing those levels or any levels as representation of impairment. I would remind the committee, and perhaps not necessary, of Senator Cunningham reference to the studies by the American Automobile Association conducted in partnership with the International Association of Chiefs of Police. Their conclusion was there is no correlation between the two. It depends on so many factors. Our organization, we're not scientists, we are not biologists, we are not toxicologists, but we do question seriously the evidence base for the per se offences and suggest that the government might want to delay the implementation of those provisions until such a time that the science is better. The second point I would like to make, and hopefully briefly, is the use of regulation to establish the blood drug concentrations. We believe that it is critical of the criminal justice system that norms that establish the line between innocent and criminal behavior be in the law, just as the BAC is now. We believe that's important for those levels to be publicly debated before Parliament. We also believe it's important for accessibility, both for the public but also for the legal profession. Our third point, quite briefly, and I will call on my colleague François to speak to this, is with respect to the mandatory alcohol screening.
Yes, Senators, I'll be very brief. Essentially, the CCJ believes that there are still many alcohol-impaired drivers that are on our roads, and mandatory alcohol screening would significantly reduce that number. And if we look at different Commonwealth and European jurisdictions that have enacted such laws with notable success, we believe that it may be an interesting way to work. Mandatory alcohol screening may also serve court efficiency purposes by lessening the evidentiary burden of the Crown, and we do recognize the Charter risks of mandatory alcohol screening, yet the CCJ believes there are good and valid points that could, arguments that could justify the violations under Section 1 of the Charter. Unfortunately, our courts will be the ones to make that decision, but the CCJ believes that there are good and valid arguments.
Thank you.
If I may, Mr.
Quickly.
Chair, two other points quite briefly. We're very concerned about the continued use by the government of mandatory minimum penalties, notwithstanding the clear criminological evidence against that. We would suggest one need look no further than the Department of Justice documentation themselves under their website. If you look under the heading, "Why are we transforming the criminal justice system?" under another heading called "Less discretion for judges," and I quote, "Some suggest mandatory minimum penalties provide certainty in sentencing and help to ensure people are treated equally. In practice, though, they often make it hard to ensure the punishment fits the crime." The Department of Justice goes on and says, "Studies in the United States and elsewhere show that they do not deter crime. Recent data suggests they result in shorter sentences, fewer guilty pleas, and longer trials, including more charter challenges. More victims are forced to testify and backlogs increase." Again, in the words of the Department of Justice posted. We think the evidence is quite clear. The Supreme Court of Canada has spoken in Nuhr, in Lloyd, the Ontario Court of Appeal in the past year in a case called Morrison, dealing with sexual offences against children, where a mandatory minimum was struck down. There cannot be a more serious offence than that. Quite recently, two Superior Court decisions. Yes, of course, Mr. Chair. I apologize. The case law is clear. We suggest that mandatory minimums are bad law and bad policy. And on one final point, we really would implore the federal government to increase its support and funding for drug treatment court and treatment programs and other restorative solutions in a hope of finding a more humane and lasting solution to some of these problems.
Thank you.
Thank you. My apologies.
Thank you. No, that's fine.